We're just on noon.
Okay, hi, good afternoon, everybody. We are here right now to co-host a webinar for you that you all registered for, so I appreciate that on this beautiful rainy day here in Connecticut. It doesn't feel like spring at all, but what I want to let you all know is that we will be going over a few items to make sure that you understand what is FMLA and Connecticut paid leave, what are the qualifying reasons for leave, and most specifically, how do you apply? The goal here is to make sure that you're all aware of being in compliance, and most importantly, you have options as well if you'd like to be fully insured. So I'm going to pass this over to Erin Choquette right now at the from the state level, and she could take it away.
Terrific. Thank you so much, Michael. So I'm just going to reiterate what I put in the chat. We are recording, and we will share the recording and the slide deck with you so you can share it with the folks who have attended. If anyone has any questions as I go through, it would be great if you could use the Q&A function. So write your questions. We'll have time to get through them after I go through the slide deck. Putting them in the chat, it makes it hard to keep track. So the Q&A is really the way to go. And with that, I will get back to the slide deck. And there we go. All right. So as Michael said, we're going to talk about the paid leave program, a little bit of understanding to make sure everyone has an understanding of what FMLA is and how it's different than Connecticut paid leave. So we're going to talk about the qualifying reasons and then really focus on what you should know about Connecticut paid leave and the private plan alternative. And we'll share some additional resources. And then, as I mentioned, we'll get to the questions that you put into the Q&A. So just briefly about the Paid Leave Authority. We are a quasi-public agency. We were created by statute. We're coming up on 3 years from the effective date of the legislation. Our board was created in the fall of 2019. We hired our chief executive officer as our very first thing to do. And 12 days after she came on board, we were all sent home to work from home for the duration due to the pandemic. So we've been created entirely remotely, entirely virtually, and we've been very busy in the past 2 years. Our goal is to provide pathways for workers to access paid leave benefits. That's the purpose of our existence. But we also think it's equally important to make sure that employers, administrators, and healthcare providers all understand their roles and make sure that they have tools and the information they need for their part of the process to go as smoothly as possible. I am Erin Choquette. I'm the General Counsel and COO of the Authority, and I'm an employment lawyer with a lot of experience in FMLA. So it's kind of a culmination for me to be working with the Authority on leading this new program. Just a couple of key dates. Hopefully these are things you're very familiar with. We have been receiving contributions for the program since January 1 of 2021. The paid leave program in Connecticut is entirely employee funded. So the employees contribute 0.5% of their wages, and we calculate wages the same way you calculate wages for FICA purposes, up to the Social Security cap. So the employee responsibility is to give us the money. The employer's responsibility is to handle the payroll. So the employers deduct those contributions from the payroll, and the employers remit the funds to the Authority. Those contributions are due every quarter. The deadline is actually the end of the quarter, but we do give you a 1-month grace period to get the contributions in. So we've been doing that for 1.25 years. And in January, paid leave benefits became available to employees. We actually opened the claims portal a month early to try to kind of skim off some of those early claims so that folks who knew that they had claims, they could get those in early, but benefits became available for absences that started on or after January 1st of 2022. As I mentioned, I want to make sure we're all clear on the difference between FMLA and CT paid leave. So let me just define FMLA. Those letters stand for Family and Medical Leave Act. Actually, there are two that you need to be aware of, the federal law and the Connecticut FMLA. As statutory entitlements, they have been around since the early 90s. Both the federal law and the Connecticut FMLA allow eligible employees to take job-protected time away from work if they have certain qualifying family or medical reasons, which I'll discuss. These leaves are administered by the employer. So the employee requests the time off from the employer. The employer is responsible for determining eligibility under the laws and tracking the leave. Leave under FMLA is unpaid. The entitlement is the job protection. Employers are entitled to adopt policies to provide their employees with income replacement while they're out on leave, but it's not mandated. Many employers do provide some sort of income replacement to their employees while they're out on leave. Perhaps it's just continuing them on their regular pay. We're just going to keep you on the payroll, that's whatever you were earning, and that's fine. More often, we see employers say, we provide you with sick time, we provide you with vacation time. We will either require you or allow you to use those accruals while you're out on leave. And then other employers will combine that or offer as an alternative short-term disability that may provide income replacement for certain leave reasons associated with an employee's own health condition. It's very important for you to be aware of the changes to the Connecticut FMLA that took effect on January 1st. The most significant of those changes is that now employers in Connecticut with one or more employees are covered by Connecticut FMLA. That used to not be the case. It used to be employers with 75 or more employees in Connecticut. So if you have fewer than 75 employees, you've never dealt with Connecticut FMLA before, now you have to. In order to make time for everything we wanted to cover today, I'm not going to get into too much of the Connecticut FMLA changes, but I'm happy to discuss that in the questions. Just generally speaking, as I mentioned, FMLA is managed by the employer. Really, the direct relationship is between the worker and the employer. The worker's responsibilities are to notify the employer that they need to take time away from work. They don't have to use the phrase FMLA or say I need family medical leave, but they do have to convey to you enough information. Hey, my dad's going to need hip surgery. I'm going to need some time off. Enough information that I need time off from work for what is potentially a qualifying reason, so that you, the employer, can manage the leave process. If you require employees to submit a written application, then they have to do that. You will want documentation to substantiate the leave reason. They have to provide that. And they still have to comply with your attendance and call-in policies. As an employer, you're responsible for understanding your FMLA requirements, establishing a clear leave policy so your employees understand. And that includes making sure your employees know what your rules are about whether they are allowed to or required to use PTO when they're out on leave. There are some posting requirements that are established by the federal FMLA and the Connecticut FMLA. So if you're subject to federal FMLA, which you are if you have more than 50 employees or you're a governmental entity, you'll have to post that poster. And then you'll be processing those leave requests, monitoring leave usage, managing that return to work, and of course, refraining from discriminating or retaliating against your employee. So that relationship is really between you and your employee. You need to know that the Connecticut DOL is responsible for promulgating regulations about Connecticut FMLA and providing guidance. They have sample forms. They have helpful information that you can find on their website. And they also investigate complaints regarding denials of FMLA, as well as complaints relating to claims of discrimination or retaliation on the basis of an employee using FMLA or asking about FMLA. Just a note about those regulations, they have draft regulations that are in the process of being adopted. The next step is for them to go to the legislature for final approval. On the federal FMLA side, the federal DOL promulgates regulations and provides guidance, and their website is on the slide as well. and they also investigate complaints. Both the Connecticut DOL and the federal DOL offer sample forms that I encourage you to use so that you make sure you have all the information that your employees need. The Paid Leave Authority has no actual responsibility relating to FMLA, but because of the interaction between CT Paid Leave and FMLA, we like to share this information with you. Which brings us to CT Paid Leave. What is that, or CTPL as we refer to it? CTPL references the Connecticut Paid Leave Program, which was created by the Connecticut Paid Leave Act. That was the law that was passed in 2019 that creates a source of income replacement benefits for employees who cannot work for the same reasons as FMLA. The eligibility standards for CT Paid Leave are different from the eligibility standards for both FMLAs. So it is possible for an employee to be eligible for CT Paid Leave benefits, but not be eligible for job protection under FMLA. I make a point of that because it's really important for you and your employees to know that CT Paid Leave does not provide for job protection. We provide for the money if the employee can't work, whether or not they have job protected leave. CT Paid Leave is administered by the Paid Leave Authority, and we have a contract with a third-party administrator to process the claims, and we've contracted with AFLAC for that. The relationship here is really between the worker and the authority for those benefits. You often hear people talk about paid family medical leave or PFML. It's the same thing. We just don't like to say PFML because people hear FMLA, and that exacerbates the confusion between the different entitlements. There are two sides to the paid leave program. The first are the contributions, which I've alluded to, and the second are the claims. For contributions, the responsibility is the worker pays the money, right? So they contribute 0.5% of their FICA wages up to the Social Security contribution limit. The employer's responsibility is to, with regard to the contributions, is to get that money to us. And you do that by creating an account with us at our portal, deducting that 0.5% from the employee's wages, and remitting it to us on the quarterly basis. We ask for relatively limited backup information just so that we know that we're getting the full amount. We're not asking for detailed wage records or really any sort of individualized wage records, but we do need to have an understanding that, oh, payroll was 100,000, the remittance is 0.5%, right? On the contribution side, we at the authority receive and reconcile those contributions. We process overpayments and underpayments. And starting this spring, we will be imposing penalties for non-compliance. We have not done that yet because in concert with the Connecticut DOL, we have been allowing a catch-up period. That catch-up period ended last week on the 31st of March. For the past year and a quarter, we recognized that this was a new program for employers. We wanted to give employers really every opportunity to get themselves caught up, to get compliant. So we were very willing to kind of work with delays, make sure people had the opportunity to get all the money in. But now we're a year and a quarter in. The catch-up period is over. So now if an employer has not complied with the contribution obligation, they have two options. They either have to ask DOL specifically for individualized permission to take additional deductions from their employees' wages, which requires employee consent, or the employer has to determine what contributions they should have been deducting and make up the difference themselves, bearing the tax consequences of covering a cost that really belongs to the employee. Either way, as I mentioned, starting in this late spring, employers that are not compliant with their obligation may be charged interest for the delays, and if there's a cause, we may be imposing penalties, just so you know. So that's the contribution side, and there's the claim side. With the claim side, we relate directly with the employee. The employee submits the application to us directly, either through our portal or by calling AFLAC They start the process. They're asked to provide supporting documentation based on the leave reason. Once the claim has been approved, they may need to provide us with updated information about their absences or other sources of money. And so that's the employee's responsibility. The other thing the employee must do is notify their employer that they've applied to us for benefits. That's in the statute that they must provide that notice. In practice, usually that happens when the employee gives the employer the employment verification form that we need. It is the employer's responsibility, right, for the pop-ups. It is the employee's responsibility to give the employer the employment verification form. It's the employer's responsibility to complete the employment verification form. It's a two-sided document where we request information about the employee's schedule so we can determine their weekly schedule. We ask for information about whether the employee is receiving any funds from you, because we have to reconcile that with the benefits we provide, and a couple other pieces of information. So as the employer, you receive that from your employee and you submit that to us within 10 calendar days of receipt. We do need you to let your employees know what your PTO policies are so that they're not confused, and of course, don't discriminate. We at the authority with AFLAC determine eligibility for benefits, which I'll go through. We review those documentations to approve or deny the claims as appropriate. We calculate the benefits. The benefits are paid each week, and we issue them either through direct deposit or through a debit card. And of course, we monitor ongoing claims, we investigate any potential fraud, and we can impose penalties on the employee for fraud. We can also impose penalties on an employer or healthcare provider or anyone else who aids and abets in fraud. The Department of Labor is responsible for hearing appeals. So if we deny a claim, the worker can file an appeal with DOL, and they will hear whether the denial was appropriate or not. And they will also have the ability to hear appeals if we impose penalties associated with fraud. DOL does not have authority over penalties for late contributions. Okay, so I've mentioned that you have to be out of work on a qualifying reason to receive benefits from CT paid leave. These are the same reasons that an employee could receive job protected leave under FMLA. Just run through them. They should be pretty common and pretty familiar to you. The first and most frequently used reason for leave is an employee's own serious health condition. So they need time off from work to receive treatment for or recover from their own serious health condition. Now, technically under the law, serious health condition includes serving as a bone marrow or organ donor, and it also includes being pregnant. So people always ask us about pregnancy as though it's not a serious health condition, but it is defined as a serious health condition. Then there's bond taken not to be pregnant or recover from childbirth. This is a time taken to actually physically and emotionally kind of create their time spent with the child to create that physical and emotional connection with the child. You can take bonding leave to bond with your newborn child or a newly adopted child or a newly placed foster child. Both parents may take bonding leave, right? That's perfectly acceptable. But only the parents can take bonding leave. This is not available for sort of the rest of the family. Bonding leave may be taken anytime during the 12 months after the birth or placement. And as I mentioned, it's for birth, adoption, or foster care. We also have caregiver leave, which is leave taken by a worker to provide care to a family member who has a serious health condition. Now, that care can be in the form of taking them to the doctor's office. Perhaps in some situations, it's actually, working with them on their physical therapy. But it also can simply be being there, providing that psychological care and comfort that your loved one needs. In addition to those three, which are the big three for purposes of leave and benefits, there's a few others you should be aware of. Military caregiver leave is a specific leave type for an employee whose family member has been injured in the line of duty on active duty in the armed services. For FMLA, the definition of family member is pretty broad with regard to military caregiver leave. It includes parents, grandparents, cousins, and next of kin. For qualifying exigency leave, that's when your employee has a parent, spouse, or adult child who has been deployed or has been notified of a deploy to active duty. And there are specific reasons that the employee needs to take time off from work to address kind of the change in circumstances associated with that deployment. It could be that they need to attend sending off ceremonies sponsored by the branch that the parent, spouse, or child is in. It could be they need to make some legal appointments to change their will or set up some powers of attorney. Maybe they need to make some appointments with the bank. It may be that they need to take some time off for emergency childcare or to set up childcare for the child of the deployed service member. There are actually 9 reasons in all for qualifying exigency leave. Then finally, there's the Family Violence Leave Act. So this is a separate Connecticut statute, separate and apart from FMLA, which says an employer must allow their employee to take job-protected time away from work up to 12 unpaid calendar days in a calendar year if that employee is a victim of domestic violence or family violence and needs the time to seek medical or psychological care, counseling, to obtain services from a victim services organization, to relocate due to the family violence, or to participate in a court proceeding. Under the Connecticut Paid Leave Act, we will provide income replacement benefits to an employee who's taking that unpaid time from work for those reasons. So, mention the definition of serious health condition includes organ donation or bone marrow. I wanted to just let you know that the definition actually is pretty detailed. It includes people who have to stay overnight in a hospital. It includes people who have incapacity of more than 3 consecutive calendar days, where they see a healthcare provider within the first 7 days, and that healthcare provider determines that they need medical treatment. It could also include a person who has a chronic condition, so their incapacity might flare up from time to time. It may not be that they're always out, and they need treatment from that healthcare provider, and they see that healthcare provider at least 2 times a year. It includes permanent or long-term conditions that maybe don't require treatment because there's really no treatment available. We're really talking about palliative care here, but they're still under the supervision of a healthcare provider. Of course, there's always these treatments, conditions where it's non-chronic, but if you didn't treat it, it's going to be a chronic condition or a serious health condition. And so here you're really talking about injuries, surgery, that kind of thing. And then, of course, pregnancy, which also includes prenatal appointments. It doesn't require only that the person have complications. A regular prenatal appointment counts. We want to make sure people understand the statutory definition of a serious health condition, particularly with relation to COVID, because a lot of people in the past year, but particularly for us, our purposes in the past 3 months, may have been diagnosed with COVID, may even have had a tough run with COVID symptoms, but never received any treatment. They were not medically required to receive treatment, and therefore they didn't have a serious health condition. And so that was something of a difficult message to tell people who couldn't work, but if they were not medically required to receive treatment, be in the hospital, it didn't count as a serious health condition, so it doesn't count under FMLA, and it didn't qualify for benefits. The other big thing I want to let you know about is with regard to caregiver leave. So that list of reasons is the same for both federal and state FMLA, and obviously CT paid leave benefits. But there's a very big difference for caregiver leave, which is one of the changes in Connecticut law. Under federal FMLA and under the old Connecticut FMLA, you could only take caregiver leave for your parent or your spouse, or a child who was under 18 or was 18 and over and had a disability that precluded them from engaging in activities of daily living. But now, under the new Connecticut FMLA and under paid leave, caregiver leave is actually available for a parent or a spouse, a son or daughter of any age, as well as a sibling, grandparent, grandchild, or a person related to the employee by blood or affinity whose close association is the equivalent of one of those family relationships. So again, your caregiver universe is broader under the Connecticut laws. That affinity relationship is a concept that is relatively new to Connecticut, but has been sort of on the books with federal law, with federal leaves for federal employees, as well as in some other states and some large municipalities. The idea here is that families come in all shapes and sizes, and we really need to recognize the relationship and not necessarily the kind of legal accoutrement that you might have seen. So you are allowed as an employer, if an employee asks to take caregiver leave for a family member, to ask for a statement of the family relationship and ask them to explain how this person is the equivalent of a parent, spouse, child, sibling, grandparent, or grandchild. It has to be a simple written statement. You're not allowed to ask for a notary. You're not allowed to ask for additional documentation, videos, photographs. This is in the statute. The DOL has a form you can use. The Paid Leave Authority has a form you can use. It's on our website. We know there was a lot of concern about this when the law first passed, but in practice, we're really seeing this in, sort of like, oh yeah, that makes sense kind of situations, right? Perhaps the employee has an aunt or an uncle who didn't have any children, and they are really stood in the role to them of a parent or a grandparent. And now that aunt or uncle is older and needs their help. We see this most often in the situation of unmarried significant others. So Connecticut doesn't recognize common law marriage. So up until now, if you didn't have a wedding and a marriage license, we didn't consider you to be a spouse. You couldn't take FMLA. With the new law, you don't have to have that license. You have to be that person with whom your employee shares a spouse-like relationship. So think, Kurt Russell and Goldie Hawn. Like they've been together forever. They've raised family together. They should be able to take leave to care for each other. And so now our law recognizes that. All right, I told you I'd give you some details on CT paid leave. Let me start with a very big one. Am I a covered employer? Most likely, yes. Almost all employers who have one or more people working in Connecticut is covered. The focus is, where are your employees working? And we really look to, where do you report them as working for purposes of unemployment? If you're reporting them as working in Connecticut, and so you pay into Connecticut unemployment insurance, we're considering you as working here too. If you're not subject to unemployment insurance because you're one of the exclusions, there is a process where we look to see, okay, what are the factors? Like, are they working here? Do they receive their job assignments from a central location here? There's 4 factors. The state of Connecticut is also a covered employer, as to our non-union employees. The statute does identify certain entities that are not covered, including the federal government, because we can't tell them what to do. Municipalities and local and regional boards of education are excluded unless their unionized employees collectively bargain to participate. And if that happens, their unionized employees and their non-union employees come into the program. Non-public elementary and secondary schools are excluded. And then railroads, governments of other states, and other sovereign nations are excluded. That's not listed in our statute, but that's as a result of federal law and the supremacy clause. The next big question is, who's eligible for benefits under CT paid leave? Well, first you have to work for a covered employer. And if you're not currently working for that covered employer, we're going to look to see, did you work for a covered employer here in Connecticut in the 12 weeks before you applied for the leave? We do allow sole proprietors and self-employed individuals to opt into our program. They're not required to, but they can choose to. And so they have to be enrolled in our program. And as of January 1st, they have to be enrolled in the program for at least 3 months. So it's the first calendar day of the month, 3 months after they enroll, 3 full months after they enroll, they can receive benefits. The other thing is that they have to earn enough money. They have to earn at least $2,325 in their highest earning quarter if we look at the first 4 of the 5 most recently completed quarters. And again, that earnings has to come from a covered employer. But if they have multiple jobs, we're going to look at all of the earnings. We have access to data from DOL and DRS that enables us to see what employees reported. And so we're like, oh, you worked for 3 employers that quarter? Let's add them together. So just this graph just sort of shows what we mean. For folks who are applying for benefits now, we're looking at each of the quarters in 2021 to see if they met that 23-25. The quarter that just completed, the 2022, we do not look at. That's the 5th. And then, of course, we can't look at anything right now because it's not a completed quarter. For purposes of CT paid leave, the authority makes this determination, not the employer. The next big question is, what are the benefits? Well, it depends on how much they earn. We look at the first 4 of the 5 most recently completed quarters and their earnings from Connecticut employers. We look at the highest 2 quarters, divide that by 26, and that becomes their estimated weekly base amount. If that is less than or equal to 40 times the Connecticut minimum wage, their benefits are 95% of that number. If they earn more than 40 times the Connecticut minimum wage, there's a 2-part calculation, but it's important to know that in all circumstances, benefits are capped at 60 times the Connecticut minimum wage. We have a benefits estimator on our website to help folks kind of get a sense of what their benefits might be, and if they're in that 95%, that 2-part calculation, or if they're capped. The benefit entitlement is for 12 weeks in a 12-month period, and we use the look-back method. For all of those leave reasons I mentioned, including military caregiver leave. The reason I spike out military caregiver leave is because under FMLA, the job protection for military caregivers is 26 weeks, but we only provide 12 weeks of benefits. There are 2 exceptions here. For family violence, we're only providing leave for the 12 unpaid days that are provided under the statute. And for pregnancy, the statute says that an employee may receive an additional 2 weeks of benefits if they have an incapacitation during pregnancy. So because of the way the statute defines it, incapacitation during pregnancy could mean some sort of complication or bed rest. It could also mean just the treatment, like even regular prenatal visits are included in the definition of incapacity. So we include it too. Or it could be some other unrelated serious health condition. You know, the pregnant person breaks their leg, they could access those 2 weeks. The 2-week sort of bonus, if you like, is only while the person is pregnant. Once the baby's born, there's no more extra 2 weeks. The next big question is, how do the CT paid leave benefits interact with employer-provided benefits? And that really is based on what the employer requires. Our statute says that an employee can receive benefits concurrently from the CT paid leave and the employer, provided the total amount does not exceed 100% of their regular wages. So we ask the employer on that employer verification form I mentioned to tell us, is the employee receiving any PTO? If the answer is no, great, check the box. Then we know we'll just start processing the benefits from the first day. If the employee is receiving PTO or other employer-provided benefits for the full amount of time, that's equal to their full wages, so they're fully whole, great. We're not going to be providing benefits to them. Their entitlement with us is not touched at all. It's that 12 weeks still remains available for some other purpose, but they don't need it from us right now, so we're not going to do it. More often you see, okay, well, I've got 3 weeks of leave. I've got 10 weeks of leave, but I only have a few weeks of PTO. The employer says, okay, they're going to use 2 weeks, and then they go to you. It's important to note that under Connecticut FMLA, employers can no longer require employees to exhaust their PTO while they're out on FMLA. They must allow them the option of holding on to 2 weeks if they have it available, up to 2 weeks. So that extra 2 weeks often, or that 2 weeks that are held in reserve, is one of the reasons why scenario 3 is the most common. Then there's scenario 4, which is the employer provides some PTO that's less than the full amount of pay. So maybe they're providing 60%. We ask, okay, are you the primary payer or are we? If we're the primary payer, we'll pay whatever the statutory calculation is, and we'll tell you what that weekly benefit is, and then you can do whatever you want to do to top it off, to make them whole, whatever you decide. You don't have to make them whole, but many do. If you tell us you're primary, it gets a little complicated because you tell us what you're going to pay at a percentage. You're paying 60%. We will then pay 40% of the calculation. It's not an exact science because you're paying off of regular wages and our benefit is off of the highest 2 quarters from the first 4 of the 5 most recently completed quarters. So it's essentially adding an apple and an orange to make a banana. So your 60% regular wages plus our 40% benefits may not equal 100% of regular wages, but it's the closest way we could come to square the circle. So you should just know that if you're primary. All right, let's talk about the private plan alternative. So what I've been talking about so far is the paid leave program as administered by the Paid Leave Authority. But the statute allows employers to use a private plan to meet their obligations under the Paid Leave Act to make sure the employees have access to income replacement. If you want to do this, you have to apply to the authority for permission. And what you're saying is we will administer the claims. If you get permission, you no longer remit contributions to us. You can use the equivalent amount to help fund your private plan, but you can't require your employees to give any more than what they would have given to us. So that 0.5%. Private plan can consist of either an insurance policy or a self-insured plan that is supported by a surety bond. If it's an insurance policy, it has to be a policy that's issued by an insurer that's been approved by the Connecticut Insurance Department, and their policy form document also has to be approved. If it's a self-insured plan, the plan has to be consistent with the policy that we've created about requirements for self-insured plan. And we've also given you a template for what that self-insured plan should look like. And it's supported by a surety bond, which is runs to the benefit of the authority, and it's equivalent to the estimated contributions of your employees for a year. The surety bond does not support your ability to pay benefits. The surety bond exists in the event that you terminate your plan unexpectedly and your employees come to us. We get that year's worth of contributions to make up for the fact that they haven't been contributing to us. The full requirements can be found on our website, including in that policy that I mentioned. So I've got sort of a screenshot. If you scroll on to, I want to apply for a private plan, you'll see some information. Just full disclosure, we are in the process of updating this website because we're no longer doing provisional approval. But if you click on the policy document, you'll see the information. If you're interested in the self-insured plan, it's very important for you to use the surety bond we've provided, not just a generic surety bond. But in general, the requirements are that the benefits must be equivalent or better. This is why a simple short-term disability policy that you may already have is not going to be enough, because that STD policy isn't going to cover military caregiver, it's not covering qualifying exigency, it's not covering bonding usually, certainly not covering regular caregiver or family violence. So you need something that actually covers all the same reasons, has the similar eligibility or equal or more generous eligibility requirements, equal or more generous benefits. As I mentioned, it cannot cost the employees more, and it must cover all of your employees in Connecticut. If you're a multi-state or multinational, we're not saying you have to give this to the folks outside of Connecticut, but everyone in Connecticut has to be covered. You can't have a private plan just for your executive suite and send the rest of your employees to us. And under the statute, before you can even apply, your employees must approve the proposed private plan. So our policy includes the rules for what that vote must look like. Before you apply, you need to figure out what your policy is going to look like. Is it going to be insured or self-insured? You need to educate your employees about the plan, and we give you a plain language guide template that you need to modify that you give to your employees with your plan documents so they can review it, ask any questions, and then you hold a vote. The vote must be anonymous, and the majority of your employees must vote in favor of moving ahead with a private plan. You have to give them at least 2 weeks between when you give them the guide and when you hold the vote, so they have time. And again, you have that surety bond obligation if it's self-insured. When you're ready, you'll go into your account, which you've already created on ctpleave.org. You'll click on your business name, and then there's a tab that says private plan, and they give you step-by-step instructions. It doesn't take very long. The work is really in the prep. And then we review. You're going to be uploading your plan documents. as well as the plan language guide. We're going to ask you for some information about the vote, and you're going to attest to your compliance and that you will direct your insurer or TPA to do the same. We are continuing to accept applications. I actually have a queue that I need to get to with a handful of applications that come in. Because the claim is now open, we only accept applications and we only approve applications on a prospective basis, right? Like we can't approve an application and say, and have a confusion as to who's responsible for a claim that happened last week. So now applications must be approved no later than 30 calendar days before the end of the quarter, prior to the quarter in which the approval will take effect. Which is sort of a gobbledygook, so the examples are supposed to help here. For plans that took effect on April 1st, they had to have been approved by March 1st. That gives us time to make sure that they know they're approved, the insurer or self-insured plan can be ready, and AFLAC can transition anyone who's got an existing claim to know that as of April 1st, they have to go to their private plan. So currently right now I'm approving plans and those will take effect on July 1st. Those applications have to be approved by June 1st to take effect. And contributions continue to be owed until the plan takes effect. So if you've got an application currently pending with me, you still owe the 2021 contributions, of course, as well as the contributions for the last quarter and this coming quarter. Approvals are effective for 3 years, or if you make a material change, that terminates the approval. So if you want to change your plan, you have to submit for a new application. Security bonds have to be updated on a yearly basis because your contribution estimate may change. We can deny or revoke claims if there's any sort of problems. Threaten the employees, coerce them, fail to pay benefits, pay the benefits but have undue delays, fail to maintain the surety bond, misusing the funds, failing to provide us with documentation or providing false documentation. Again, if you fail to follow the rules, we can deny your plan or revoke. Okay. I think I've hit most of the FMLA and I want to make sure we get to the questions. But again, FMLA is Family Medical Leave Act. This is the job protection. You're covered if you have 50 or more employees. Under federal, you're only covered if you have 1 or more employees in Connecticut. And to be eligible for employees, for federal FMLA, they have to work for you for 12 months and 1250 hours. But under Connecticut FMLA, they only have to work for you for the 3 months before going out on leave. So more employees are eligible. All right. The leave is 12 weeks in a 12-month period, basically. And I won't go through this because I think I've hit most of it already. So I am going to skip to the end because I do see we have some questions. When you see this slide deck in person, you'll see that I've shared some links to our website with some information for you for helpful guides, documents you can share with your employees about what to do with the program, what the program's all about. So that'll be available to you. But let's go into the questions.
Would you like me to read them all for you, Erin, or you're
yeah,
okay?
That'd be great.
Yeah, well, thank you for doing that. That's a lot to absorb, obviously. There's a lot to know, but it's very important. The first one from Charlotte, I don't know if she's on still or not, but I believe we answered that already. Connecticut FMLA is now 12 weeks in a 12-month period, correct? The answer is yes.
Yep.
The next question is Barbara Skinner. Are we required to distribute both Connecticut FMLA and FMLA forms to employees who go out on leave, as both can run concurrently? Yeah, my initial inclination is yes, if she's referring to the federal FMLA, I'm assuming.
Right, although you can, so if you look at the Connecticut FMLA form and you look at the federal FMLA form, they're basically the same. So you could kind of adapt them and create one form that has all of the same information so that you only have one document that you're handing out. Like that's allowed. Both Connecticut DOL and federal FMLA allow you to do that. You just want to make sure that you're kind of checking the box to be like, okay, federal says I need to have all this. State says I need to have all this. Got it. One simple form. If you are large, you want to, you probably want to do that to make life easier for yourself.
Got it. The next question is slightly easier. Teresa, can we print this information? We are recording this. I'm assuming will this be emailed out to us and so we could share it with the rest of the people that joined?
Absolutely.
Okay, terrific. Next question, would approved payment for qualified leave be applied retroactively if the employee does not submit their app in a timely fashion or due to an emergency? My initial answer there is no, but you're the expert.
Well, actually, we do. So the requirement for us is similar to FMLA. We want you to apply 30 days in advance for foreseeable, or as soon as practicable if it's not foreseeable. So, you don't know you're going to get hit by the bus. You can't apply early for that, but we'd want you to apply as soon as practicable. If there is a delay in applying, we're going to look to see why there's a delay. And, if it's a few weeks, that's not an issue. But if it's, you're getting into several weeks, we're going to be wondering, was there good cause for delay? But we will make that payment retroactive to the beginning of the leave or the sort of unpaid portion of the leave.
Okay, terrific. Thank you. Next question. Once a claim is approved, we as the employer do not receive standard information from AFLAC regarding the amount approved, which makes it difficult for us to properly calculate how much PTO should be applied. Will this change in the future? Should we handle this differently? Paid leave is considered first, and STD, PTO. Will this be audited? Do you want to start with the first portion now about whether or not this, the standard information from AFLAC?
So what's supposed to happen is that when a claim is approved or denied, an email will go out to the employer, letting them know employee applied for serious health condition, pregnancy, whatever it is, for this period of time. Claim has been approved, estimated benefit is X, or the claim has been denied. We've had some difficulty making sure that those messages go out for a variety of reasons. The email is based on the contact information that's supposed to be provided in the employment verification form. Sometimes it's not provided, or it's it's like a supervisor fills it out, and that's not good. The supervisor is getting this information, and your benefits team needs it. So we do ask employers to really identify what department in their shop or person in their shop should be filling out those forms, and make sure that that email is filled out. And if you have like benefits at xyzcompany.com, that's fine. That's great as far as we're concerned. We've had some glitches with that because if you've got employees with multiple employers, the automatic only goes to one employer. And so we've had to do some remedial training with our folks to make sure that they notify all the employers. But we're also looking to develop some reporting so that we can just create reports for employers to be like, here's all your employees, approved, denied, pending, so that we can make sure you're getting that information. So that's a work in progress for us. Okay. On terms of the STD PTO side, if you tell us that you're paying 100% for 3 weeks, then we start paying on week 4. Easy peasy. If you tell us that you're going to pay something less than 100%, or that we're first, if you tell us that you're going to pay something less than 100%, we ask, is it primary or secondary? If you say, we want you to be primary, we'll be secondary, we say, okay, we're going to pay our benefit. It's up to you to do whatever you're going to do. And it's your responsibility to make sure the employee doesn't go over 100%. That's on you. We're not auditing you. We're just putting that on you because you've got the data to be able to do that. So I think those answered all the questions that you listed out.
Correct. That actually segues into the next question as well. Someone else had asked, what would be primary? So you addressed that already. As far as who decides?
The employer. Or in some cases, the insurance company that issued the short-term disability policy that the employer has. But the
Correct.
employer is the one who tells us.
Exactly right. The employer, correct. Other question here that we have is from someone else. We have an employee who's going out on leave in May due to a pregnancy. As an employer, we offer short-term disability for 3 weeks at 100% of pay, 75% of pay for the next 3 weeks, and 60% of pay for the next 2 weeks, and then the employee will use paid time off. The question is, does the employee have to apply for Connecticut paid leave and submit an application?
As far as the statute is concerned, and as far as we're concerned, no. You're incredibly generous. They can save their CTPL entitlement that they've paid for whatever other reason they want. But you want to make sure that your policy doesn't include any little traps for the unwary. Some STD policies say that the employee, that they want to be secondary, that there's, contractually that they're secondary. And some say the employee is required to exhaust other options. So you just want to make sure you're not running afoul of your actual policy that you have purchased. But if your policy doesn't require that, then you're great, fabulous.
I was also going to say that should segue into maybe having that covered in their handbook just as a backup as well. Yeah.
You really want to make sure your employees know what the rules are, and that means you need to know what the rules are, because we know a lot of a lot of employers are telling us that they don't know what their insurance policy says, and they ask us, and we're like, well, yeah, we don't know. Talk to your broker.
Correct. Which is why we're having this call. The other question, I believe we already answered this. Employees who have enough PTO time to cover the leave can only take PTO. Can only PTO be used instead of applying for Connecticut PFL? We sort of just addressed that previously.
Just with that 2-week exclusion that this FMLA says you can't require them to exhaust the full amount. They can choose to, but you can't require the exhaustion.
Exactly. Next question here. Full-time employees who go out on a medical leave of absence have short-term disability coverage that pays 60% of weekly pay. Would this be primary, and then Connecticut pays the remainder up to 95%?
So primary, secondary, look at your policy. The remainder, as I mentioned, our calculation depends on what they earn. And so the 95% is just for folks whose base weekly wages are less than or equal to 40 times the Connecticut minimum wage. So step 1, look at your policy, see if it says it's primary or secondary. Step 2, tell us on the form. And then if you are primary, we will adjust our benefits. If we are primary and you are secondary, we'll pay the calculation benefits as calculated by the statute.
Next question here. Is it a requirement to leave 2 weeks PTO in time off bank for someone's return of leave, or does the employee have a choice?
Employee has the choice.
And it looks like one last question here is also from Barbara. Our STD policy requires our employees to file under Connecticut paid leave. So then would we be secondary?
Most likely. I mean, that's,
yeah.
The lawyer in me is saying I can't say definitively without seeing the language, but
correct.
What you're describing sounds like you're secondary.
Correct.
They want to be the payer of last resort. If you see something like that, that means they're secondary.
Understood. And again, I'm glad that you had broached about privatized plans. That is an option, of course. I'm glad that you had mentioned about the 30 days notification. That's very important. So we are here via Alera focusing on July 1st effective dates as we speak, if anybody needs help and looking into that option as well. But right now the goal is to be compliant and make sure that you have what you are required by law. If there are no more questions, this will be dispersed internally on the Alera side. And I just want to thank Erin for the time. That was we fulfilled a good 54 minutes right there in a quick window. I appreciate the time. There was a lot of knowledge and a lot of things to know.
So there is a lot of information on our website, so ctpaidleave.org. We're updating it, frankly, all the time with like mini releases and major releases. So there's just a lot of information on our website. If you're looking for information about paid leave, if you're looking for information about the private plans, we have over 500 private plans approved. And so, from our perspective, we want the employees to get the entitlements, whether it's from us or whether it's from a private plan. If you're looking for information about FMLA, you really want to look at the CTDOL website and really make sure that you are aware of those Connecticut legal changes, because it's there's a lot of employers out there who've never had to deal with FMLA, who now have FMLA requirements, and again, 3 months instead of 12 months. So you've got a lot more employees. Even if you're used to FMLA, you've got a lot more employees who will have that job protection available to them.
I agree. And if anybody else has questions to write along that point about overall absence management that's on this call and how to track in multi-states, our website is insurancewholesaler.net. We could assist you with not just Connecticut, but throughout the tri-state, New York and New Jersey as well, if you have multiple locations. So, Erin, thank you for the time, and thank all the participants for sitting in with us to go over all this information. It was very valuable. Thank you very much.
Thank you for inviting me.
Okay,
Have a
take
good
care.
day. All right.